Good morning. Thank you for attending today. It's 9:30, so we're going to go ahead and get started. My name is Erin Callbacks. I'm the Marketing Director for Extra Help, a workforce management resource. You have joined us today for a Workplace Excellence webinar entitled Recruiting in the Age of Social Media. Our presenters today will be Susan Basford-Wilson and also Fallon Wrigley, and they will be introduced momentarily. Our webinar program is an exciting new program for our clients and colleagues to help manage their workforce changes and increase workplace efficiency. Just a couple house cleaning things before we get started. The call will last 1 hour. You are set up as listen-only mode, but there is an opportunity to ask questions. You will see a questions tab on your toolbar. Feel free to type in your questions there, and we will address them at the end of the presentation. So let's get started. Thank you for joining us, Susan and Fallon. Let me go ahead and introduce you. Susan Basford-Wilson specializes in management-side employment law, particularly focusing on litigation prevention. She handles a wide range of employment matters in federal and state courts across Missouri and Illinois, as well as successfully representing employers in administrative matters and mediation. Susan enjoys assisting employers in proactively dealing with employee issues through policy development, training, and best practices. She frequently presents and provides training to human resources, trade and employer groups on a variety of employment law issues, such as social media policies and termination procedures. Susan earned her law degree from the University of Michigan and her undergraduate degrees in journalism and psychology from the University of Missouri. Susan is also a member of the firm's Diversity Council. Fallon Wrigley represents employers in both litigation and administrative proceedings and advises clients with respect to state and federal employment laws. She routinely handles litigation involving discrimination, harassment, breach of employment and separation agreements, the Fair Labor Standards Act, the Americans with Disabilities Act, and the Family and Medical Leave Act. Ms. Wrigley also counsels management regarding employment issues, including employee discipline and termination. Fallon is also a member of the firm's Diversity Council. So let's go ahead and turn it over to our presenters, and I hope you guys enjoy and learn the presentation.
Thank you so much, Erin. Good morning, everyone. My name is Fallon Wrigley, and as Erin said, I'm here with my colleague, Susan Basford-Wilson. We are both employment law attorneys with Constantia Brooks and Smith, and we practice exclusively in the area of employment law and represent exclusively employers. So today, we're going to talk about recruiting in the age of social media. So to begin, what is social media? This may seem obvious, but with rapid changes in technology, this can mean many things. Basically, it's anything that you do online to interact with other people. The types of social media include obvious things like Facebook, LinkedIn, and Twitter, but can also include Pinterest, WordPress, Snapchat, and sites like Ask.fm, Seed, and Kick. So what does this have to do with recruiting, and why does it matter? Well, we know that currently over 50% of companies are using social media to screen job applicants. And furthermore, over 80% of recruiters state that they're using it to give guidance and recommendations to employers. Why is screening important? Again, this is obvious. First and foremost, people often lie on their resumes. I had a case recently with an employee who was working in the financial services industry. He had access to and control over private financial data of clients. He listed on his resume that he graduated from the University of Illinois with honors and was in a number of different fraternal organizations. As it turns out, he not only never attended U of I, but was actually spending time in a state penitentiary. So obviously there are many benefits to screening. However, as we're also going to discuss today, there are a number of laws that are implicated. Some of these, and as we'll discuss in greater detail, include Title VII. Those are all of your discrimination statutes based on things like race and religion. The Fair Credit Reporting Act, the National Labor Relations Act, the Electronic Communication Privacy Act, the Stored Communications Act, and state and local laws. So let's start out by discussing why this matters. Well, in 2011, the total time spent on social media in the U.S. increased 37% to 121 billion minutes in 2012 as compared to 88 billion minutes in July 2011. 51% of folks aged 25 to 34 use social networking in the office, which is the highest rate among the age group. Facebook reported nearly 1.2 billion monthly active users in October 2013, with the largest increase in those over 55. When you think about it, who do you know who doesn't have some form of social media account? There are a few, but they are few and far between. Social media has actually overtaken pornography as the #1 activity on the web. That says something about our country. I'm not sure what, but it says something. The reality is that social media is a huge, unavoidable entity. Americans aged 18 to 64 who use social networks say they spend an average of 3.2 hours per day doing so. That means for every one of us who spends half an hour on social media every day, someone else is spending 6 hours. And here's where it comes to play in the workforce in particular. 6 out of 10 employees report using social media at work. And studies show that employees are interrupted by technology every 3 to 23 minutes. So the question is not if social media is relevant to your company, but how. So with everyone using social media, what could possibly go wrong if we start using it for recruiting? Well, aside from the fact that an employer may inadvertently misjudge a candidate, they may also run afoul of a number of different laws, as I mentioned previously, including discrimination law. The important thing to remember is that if you're screening applicants online using online tools, the internet is forever. And chances are that everything you or any of your employees have ever done online is cached somewhere. And if a lawsuit arises, it may come back to haunt you. So today, we'll talk a little bit about industry trends and the perception of social media recruiting by potential applicants, e-laws, the benefits and pitfalls of online applicant screening, and then some recommendations that we have for policies and practices. We'd like you to think about what your company does. In the past year, has your company used social media to find or evaluate job applicants? If they did so, when? At the time you received an application, after the interview, or immediately before you hired them? Do you have a policy that talks about that? Do you follow your policy? Was any applicant rejected for employment or promotion based on information someone found online on social media? Was any applicant considered more favorably because of posting on social media? And from a legal perspective, here's the big one. If someone asked you to do it, could you prove it? If they filed a failure to hire lawsuit saying, you didn't hire me because I was African American, older, female, pregnant, could you prove why you didn't hire them? Let's continue looking at the impact of social media recruiting. One study of 300 recruiters found that 91% use social media to screen applicants. 47% screened applicants right after receiving the application. Only 4% screened right before the offer. So basically what that means is if you receive right after the application, before you're granting interviews or making any decisions as to hiring, you might know some protected characteristics of those applicants. 59% had rejected an applicant based on social media postings. The largest why category was because the applicant had lied about their qualifications. 68% hired applicants based on what they found in social media, with 39% explaining it provided a positive impression of their personality and organizational fit. Now, while it is obviously we want to know if someone is a good fit for the company, the problem with that is that it's very subjective. And so if you don't have a social media recruiting policy, and it's not documented and not followed, you're potentially exposing yourself to greater liability. So a recent North Carolina study sheds some more light on this and why it's so important to have a social media recruiting policy. In this study, researchers at North Carolina performed 2 studies which returned similar results. In the first study, 175 participants who had applied for a job online were told that their Facebook accounts had been reviewed for professionalism and that a decision on whether they'd been hired was forthcoming. Of those participants, 2/3 reported finding the prospective employer less attractive because they felt the Facebook screening was an invasion of privacy that reflected poorly on the company. In the second study, 208 participants were asked to envision a hypothetical scenario in which a prospective employer reviewed their Facebook profile for professionalism. Half of the participants were asked how they'd respond if they had gotten the hypothetical job, while the other half were asked how they'd respond if they hadn't gotten the job. Surprisingly, the job offer itself made little difference, with 60% of participants in both groups reporting a negative view of the potential employer due to a sense of having their privacy violated. And more troubling, 59% of participants in that second study said they were significantly more likely than a control group that wasn't screened to take legal action against the company for invasion of privacy. So this research tells us that companies need to carefully weigh whatever advantage they believe they get from social media screening against the increased likelihood of alienating potential employees. Elite job prospects have options and are more likely to steer clear of potential employers they don't trust. Let's look at another North Carolina state study. And this one teaches us about being careful about how you're interpreting what you find. In this study, 175 college students were tested to measure job-related personality traits: conscientiousness, agreeableness, and extroversion. Students were then surveyed on the content of their Facebook behavior, specifically whether they reported drug and alcohol use and bad-mouthing. This is relevant because many employers believe that reporting of alcohol or drug use means the applicant is not conscientious or responsible. However, the results of this study found that posting on drug and alcohol use did not correlate with conscientiousness. Drug and alcohol use actually correlated with extroversion. However, bad-mouthing a professor or another student did correlate with a lower agreeableness and conscientiousness score. So the lesson here is that companies may have a fundamental misunderstanding of what online behavior means and may be unintentionally eliminating desirable candidates because of what they find online. However, as a practical pointer, I would still typically recommend staying away from a candidate who is reporting illegal drug use online. There might be some exceptions to that, if they need an accommodation under the ADA. However, generally, somebody who's reporting that behavior is going to cause problems for you down the line. Let's take a look at another study. This one was conducted by Carnegie Mellon in 2013. The researchers there investigated how information shared via online social networks can lead to hiring discrimination. So researchers created a single resume for 4 different fictitious candidates. They also created online profiles for those fictitious candidates. They made one through online social media accounts only appear as a Christian male, one a Muslim male, one a straight male, and one a gay male. They then submitted those 4 resumes to over 4,000 U.S. employers. As a part of the study, they then measured how many calls for interviews each of those fictitious candidates received. What they found is that between 10 and 25% of companies searched social media networks early in the hiring process. And the difference in callbacks in politically conservative states were notable. So for instance, in states like Alabama and Arkansas, the Christian candidate got callbacks 17% of the time, whereas the Muslim candidate got callbacks only 2% of the time. There was no statistical difference between gay and straight candidates, and similarly, differences in callbacks were not statistically significant study-wide. So in other words, in New York City, there may not have been the same disparity in callbacks. This is important because if the individuals who are doing the social media screening may or may not have prejudice, and they may or may not have prejudices they're aware of. And so it's important that whatever criteria you're going to use for your recruiting decision, that you've intentionally established what those criteria are and are applying them consistently across the board. This is what we would consider to be a bad fact. If you have a lawsuit and the opposing side establishes that you had a 17% difference in who you called back based on a protected characteristic, that would be problematic. However, on that next slide, something to keep in mind is that applicants are doing the same thing to you. The internet is a two-way street. So what is your web presence saying about you? Are you paying attention to your image online? And in some, there's a soft side to handling recruiting via social media. And then there's a hard legal side, which is related to the laws we'll discuss in a moment. You need to pay attention to both. All right, at this point, please feel free to type in any questions that you may have. We're happy to, answer them as we go. All right, moving on. The laws that we're going to talk about very briefly are the Electronic Communications Privacy Act, which governs how you can treat communications while they're traveling online, the Fair Credit Reporting Act, which governs how third parties doing background checks, credit screenings, etc., can have to be handled, Title VII and other discrimination statutes, the Stored Communications Act, and various state statutes. The main takeaway lesson here is that just because it happens online doesn't mean that the normal laws don't apply. Social media screening or recruiting is not a clever method to find out protected characteristics because you can't ask it in person, so you should look it up online. Similarly, there are a few laws that specifically address online activity. 10 states have passed some form of legislation prohibiting employers from requiring applicants or employees to give access to social media. Over 30 states introduced similar legislation in 2013, and the proposed Federal Password Protection Act would have prohibited employer access to any password-protected account. And the takeaway here is that for your rank-and-file employees, it is a bad idea to require them to give you access to their social media accounts and or require them to give you their screen name and password. The exceptions to this general rule or law or state law, as it may be, are limited and few and far between. Essentially, you may be able to require this information if you have a very high-level employee in, for instance, the securities, futures, or trading industry. But as a general rule, you do not want to access this information. So let's take a look at some of the state agencies and federal agencies that are monitoring, at times, the social media activity. The EEOC has identified 6 enforcement priorities for fiscal years 2013 to 2016. Among those is eliminating systemic barriers in recruitment and hiring. The EEOC has made it clear that discrimination rules apply to recruiting. Per the EEOC, it is also illegal for an employer to recruit new employees in a way that discriminates against them because of their race, color, religion, sex, including pregnancy, national origin, age, meaning over 40, disability, or genetic information. So restrictive application processes are going to be something that the EEOC takes a closer look at. These types of processes include pre-employment tests, background screens, obviously social media screens, date of birth screens, and online applications. The EEOC is concerned with disparate treatment and disparate impact. So as an example, the EEOC has focused a lot of its attention lately on criminal background checks. Statistically, African Americans have a higher rate of arrest and of having criminal records. So if companies have a blanket ban on hiring anyone who has a criminal arrest or conviction, that could have a disparate impact on African Americans, meaning you're ultimately hiring less because of this blanket policy. That is going to raise the EEOC's attention. So similarly in the social media context, if you are doing a date of birth screen, that is going to look like a systemic barrier in recruitment and hiring. Now that we've talked about some of the bad things that can happen if you use social media recruiting and screening, let's talk about some of the great reasons to use it. You can learn good information by doing social media screening that you may not get during a typical hiring process. For example, resume inconsistencies. I am amazed and appalled how often we see this happen with our clients. Somebody provides you a resume, yet their LinkedIn profile has different dates and maybe includes a couple different jobs that they didn't bother to put on their resume. You can find out about their hobbies and about their attitude. Let me give you two examples about that one. If you are Purina, it could potentially be important to you that the folks you're hiring like or at least tolerate animals. So if one of your applicants has set up a Facebook page devoted purely to how much they hate puppies, they may not be a great fit for your organization. Similarly, let me give you a personal example. Several years ago, Fallon and I were looking to hire a law clerk. We had a huge number of great applicants, and many of them told us that they like to run marathons. I am all in favor of folks who are motivated enough to run marathons. That's just not me. So we ended up having an applicant who told us he was the president of WashU Law's Wine and Cheese Club and that he liked to eat. We actually ended up hiring him because not only did he have great qualifications, he fit in with our office culture. We really do like to eat. Searching social media provides a way for employers to learn information they normally would not and should not get during the hiring process. This includes things like age, genetic disorders and predispositions, religious beliefs, national origin, and other protected characteristics. As you all know, if you've ever looked online, this information is readily available on the site Spokio or through Zillow, for instance. We can find out this information as well as where someone lives, how much their house cost, when they bought it, and how the price of that home has fluctuated over time. So when it comes to potentially problematic posts, let's think about the following. I am so excited to run in the Susan G. Komen Race for the Cure tomorrow in honor of my grandma, mom, and sister. So why is that problematic? Because then we know about that person's genetic predisposition. Happy 53rd birthday, Bob. Again, we know that Bob is 53 years old. I'm running late for church. Celebrating Germanic Heritage Month with me. Long live the Easter Bunny. So this is information that can be gleaned from things as simple as obituaries. If you know what someone's relatives die of, that could give you genetic information. As human beings, we are all naturally nosy. And the reason we're pointing this out is, again, so that hopefully the takeaway is that you put some time and effort into crafting a social media recruiting policy. So should you, as an employer, avoid using social media to find and screen applicants? Well, the answer is it depends. It depends on what policies you have. It depends on what industry you're in. It depends on what position you're looking for, what time frame you're using to fill a position, and numerous other issues. The big picture here is that there is no one-size-fits-all social media recruiting screening policy. For many companies, I recommend a strategic advertising, recruiting, and screening plan that includes both a policy and training. I recently gave a training for management level employees at a local manufacturing facility because the company was concerned that their management would not know what they could and could not do with online activity, both when they're hiring and screening applicants, and then once that person is an actual employee of the company. So you need to think about how you want to use social media. What are you going to look for online? Who is doing it? What policies do you have in place already that could be implicated? Most of you, I hope, have an anti-discrimination and anti-harassment policy. Again, that policy is still relevant to what your company does online. Do you need another policy? Do you need training for those folks who may be doing this screening and recruiting? And what risks are you facing, and are those risks acceptable to your organization? This may seem complicated, but it really doesn't need to be. And so now we're going to walk through some recommendations that will hopefully help you determine whether you need to formulate a plan and how detailed it may or may not need to be. So first, be mindful of what is actually reflected by what you find. This is pretty straightforward. Again, you're going to want to create a systematic way of reviewing online profiles. And the individual who is going to be reviewing those online profiles needs to have direction regarding what specific characteristics they're looking for. So again, if you're hiring for Purina, you may want to have a check mark next to likes animals, or likes videos of animals being abused, okay? One example that we have, a couple of years ago, one of our colleagues had a lawsuit, a really nice physician whose new secretary filed a discrimination suit. And we took a look at all of his recruiting materials, including the resumes he'd received and his interview notes. And on the top of hers, he wrote, big boobs, long hair. Obviously not great. So if you have someone performing social media searches and they're writing down white, Christian, no indication of drinking, those are going to be very negative documents in any litigation. So be mindful of what you're looking for and be mindful of what you're tracking on paper and keeping as part of your file. With that in mind, you always want to be keeping in account the potential for failure to hire claims. As Susan mentioned earlier, these are very easy claims for applicants to file, and they can be complicated to defend because essentially all that we have in our hands as the attorneys to defend you is the job posting, the application, and the hirer's written record or testimony regarding why they made the decision. There's not a lot there. And so essentially, if you've got an application that has big boobs and long hair, and that's it, that's going to be a big problem for you. On the other side, if you have 10 applications and every single one of your applicants was female, except for one male and you hired the male, but you're able to show that through your social media, 3 of those women had lied on their resumes, and that this gentleman's attributes really aligned with your company culture, then you're going to have more defenses on your side if you happen to get a failure to hire claim. Similarly, you always need to keep in mind privacy rights online. So certainly, any employer that uses an alias, subterfuge, or pretext has likely crossed the privacy line. However, there can also be an issue involving terms of use for a social network site and for the consideration of legal off-duty conduct. Again, what does this mean? it's not advised that you create a fake Facebook account in order to research potential hires. So let's talk about some more practical policy recommendations. One is I recommend that you create and update your policy on recruiting and screening. I'm sure several of you have a social media policy right now, and it may or may not discuss recruiting and screening. You may not have a policy at all actually discussing these things. Often when I'm talking with clients, my recommendation is actually that you have several different social media policies. One is for your rank and file employee, if you will. One is for your management level employee whose actions online can reflect and be problematic for the company because a manager has the ability to act on behalf of the company. And then I also recommend a third policy for those users who are authorized to use social media on behalf of the company, which would be your recruiters, your human resources department, your public relations department. So think about what you actually need. Not every company out there needs a three-pronged policy like I just described. However, many of you do. When you're thinking about putting together this policy, think about when in the process you want to screen. For example, you have a pool of 10 applicants and you're not sure if one of them is pregnant. So you hop online and you Google only one out of your 10 applicants. That doesn't look great. If you are going to Google all of one person after interviews, you should Google all of your applicants after interview, all at that same stage. It might be a better practice to wait later on until after the interviews or immediately prior to making them a job offer to do this online screening, because then you are using it as a tool to make sure they're not falsifying their resume, or you're using it as kind of a tiebreaker to see if someone's attitude just isn't a good fit for your company. You also want to establish clear written guidelines as to what will and won't be searched and what will and won't be conveyed. What you want is to have the person who's doing this search, the designated Googler, as we'll talk about more in a minute, give you a piece of paper that says, this is what I found out online. Because then you don't know anything else that was found out online, and you can prove later on what information was conveyed to you. And finally, once you have this policy, follow it. The best policy in the world will not save you if you or your employees do not follow it. Similarly, the best practices don't help if you have a per se illegal policy. Policy and practice go hand in hand, and they're both equally important. And so just to be very clear, kind of what we're trying to convey here is that social media can and should be used as a tool. However, we would discourage you from simply searching out a person's online profile without some sort of plan in place. You should have know in your collective mind as an organization what you're looking for and why. What is the purpose of your social media search? The other big takeaway is if you can't do it in person, don't do it online. So if you wouldn't ask a question of an applicant in an interview, don't look for it online. As Susan said, if you're not sure if someone's pregnant, don't check that out. If you're trying to determine how old someone is, then you're not using social media for the right purposes. And ultimately, because the EEOC is focused so much right now on systemic barriers in hiring, you're really exposing yourselves to a lot of liability if you do so. This also applies to coworkers. So just because you're online doesn't mean it could not end up being work-related. So we want to provide training to the individuals who are performing the social media search and training to our current employees on the proper uses of social media. some of the examples of things that it would be negative to look for online include the age of an applicant, their religion, whether or not they own a home, whether or not they own a car, unless, of course, that's job-related. Arrest records or convictions for crimes unrelated to the traits that are necessary for job performance. Does it really have a bearing on the job if one of your applicants was arrested for pot use while in college 35 years ago and has had a sparkling record since then? Well, probably not in the eyes of the EEOC. You also can't look for marital status, pregnancy, child care issues or parenting responsibilities, plans to have children or the number of children someone has, unwed motherhood, race, color, national origin. Remember, once it's been seen, it can't be unseen. Once you or your employees have searched online for these characteristics, it's part of the record and can be found. What's done online will be there for an eternity. And just to clarify on that, in modern litigation, we have something called EDiscovery. And basically what this is it allows the other side to get copies of your employee's hard drive and or their email accounts. So a plaintiff could potentially see every search you made in connection with the hiring process. You might have access to every email you exchange regarding why you didn't choose to hire someone. Here's some additional screening recommendations. Designate and train a non-decision-making Googler. Susan came up with this word, so it's our favorite one. In other words, after you've determined whether or not you're going to use social media to screen applicants, determined exactly what you're going to look for, it's important that someone who is not involved in the hiring process or in making the hiring decision actually performs social media review. So again, to reiterate, those interviewing the candidate, those who will ultimately determine who is hired or not, should not be performing any social media searches on a candidate, period. And what that does for you is it provides insulation for you and the company, because if the social media search did reveal something that is a protected characteristic, like it almost certainly will, like age or race, what you can say is, hey, somebody else did that. I didn't do it. I didn't see it. I didn't know about it. That was not a factor in my decision. Look, here's that piece of paper that my non-decision-making Googler gave to me. This is all the information I knew. This is all the information that was conveyed to me based on the search that was done online. That gives us a great piece of evidence to defend you if this failure to hire suit ever arises. I know in some companies that's a hard thing to do because many folks out there are a one-person HR department. However, most of us have access to maybe an assistant somewhere else in the company who could do half an hour of research and convey relevant information to you. This is important as well because it's allowing you to be consistent. If you have one person who's trained on what characteristics they're going to look for and what sites they're going to search to find them, then again, you can show that you were very objective and applied the same criteria to every single candidate. If you have different managers and employees doing the review, they might all be looking for very different things. And you're also going to have a harder time showing which factors did or did not make it into the final analysis for the hiring decision. All right, as we already discussed, never ask for passwords to personal accounts. If you think an exception should be made, you should put a lot of time and effort into that decision and probably consult with legal counsel before going down that road. Finally, and this is probably the most important part of this, document. If you've got a policy, it doesn't have to be long, but write it down. Indicate the name of the person who's your Googler. Indicate what sites they're going to look at. Write down what factors they're going to be considering. When the Googler, you might just have them do a check-the-box approach. You might have them give detail. Again, that's part of the plan you'll create. But you want to make sure that your designated Googler is clearly indicating every step that they took. Similarly, when you actually make the hiring decision, you should document the basis for the decision to hire. If you're choosing to reject a candidate based on social media, then I would suggest documenting that. Perhaps you found resume inconsistencies. So write that down and document it somewhere. It actually takes a lot less time than you may think and can save you significant headaches and expense down the line. There's nothing worse than knowing that the company made decisions for the right reasons, but then having to settle a case or engage in litigation because there was no documentation. And the importance of documentation just can't be overstated, which is why it's so important to establish good document retention guidelines. As we've said several times now, when you're defending a failure to hire case, it's a very document-light situation. You're only going to be dealing with resumes, the job description, any application materials, and the application materials of the pool of candidates. It's much easier to defend a case if you did not hire a Hispanic candidate when 9 out of 10 candidates were white and there was 1 Hispanic candidate. However, your pool of applicants could also indicate that 9 out of 10 applicants were Hispanic and only 1 was white. If you are then hiring the white person, that paints a different picture. What we recommend is that you keep resumes for 4 years. They don't have to be physically on your site. They can be in storage somewhere, or they can be scanned in. External hard drives are very cheap these days, and I suggest to you that it's well worth the investment to keep the information about your pool of applicants, because that could be the most critical evidence if this failure to hire suit were to arise. Also, be careful about endorsing your current employees online. You may think nothing of writing a glowing review now, but once you write that review, you can't get it back if the employee changes or if the employee files a lawsuit. You could post something very positive about a former employee without realizing the real reason that that person was fired if, for example, you weren't involved in that decision. Finally, keep in mind that you may have additional obligations if your company is a federal contractor or otherwise subject to affirmative action requirements. And now we'll jump in briefly to some bonus material regarding how social media works when you're talking about current employees. You want to be careful about taking disciplinary action against employees based on their online conduct. This is the National Labor Relations Board's absolute favorite issue right now. If I were a cynical person, I would say that the NLRB has realized that unions simply don't have the market share and the dominance that they used to, and they have decided that social media is the way that they're going to remain relevant in the current society. They have stated that even non-union workplaces and non-union employees have a Section 7 right to protected concerted activity, which in their mind is Facebook or numerous other social media accounts. So anytime you're thinking about taking disciplinary action against an employee based on online conduct, you need to really think about it and probably talk to your outside counsel, because it's going to be a very fact-specific determination. However, that's not to say that an employee who does something online should never be disciplined, because there have been multi-million-dollar verdicts recently against employers who allowed employees to be harassed online, or when online conduct created or contributed to a hostile work environment. So if somebody is being discriminated against on the basis of their sex online, and that's bleeding into the workforce, and when somebody complains about it to you, you need to take that very seriously. We also recommend assessing whether you have a social media policy, as I mentioned earlier, and when it was last updated. This area of law is changing so quickly that if your policy hasn't been updated in a couple of years, it's almost certainly out of date and inconsistent with the NLRB's position right now. If you would like to be the test case where we can all finally get a clear answer to this social media stuff, that's great. I would love it if you would hire me. I would absolutely love to defend that case. However, I suspect most of you don't want to be that test case. You're also going to want to advise your employees that you own the equipment that they're working on and you monitor it. So there's no expectation of privacy for what they do online on your time or your equipment. We're hosting a webinar on a seminar on June 19th on all things e-law, in which we're discussing bring your own device questions, EDiscovery, and going into more depth about how to handle current employees in relation to social media. It's here in Clayton at our building, and we would certainly love to have any of you. You can contact us if you have more information about that. Right. And bring your own device policies are going to deal a bit with remote workers and the complications that they may face and that you may face in dealing with them. EDiscovery, again, as I mentioned earlier, in litigation now, there's so much more information available to both sides, and so it's incredibly important to be careful what you're writing in emails and how you're retaining, because that is going to be discoverable in litigation. All right, we will now open the floor up for some questions, if anybody has any. Please don't hesitate also to email us later if you think of something that you later realize you're curious about.
All right, Fallon and Susan, I do not see any questions currently, so we will keep the slide up for just a second if you all would like to take down their email addresses, and if you have any questions in the future, to shoot that over to them and also connect with them on social media. Thank you both very much today, and this was a great presentation. I do want to share our next presentation that's coming up next month. We will be doing one with Manly Feinberg with Vertical Lessons, and he's a great presenter on team management and communication within your workforce. So send me an email or wait for the webinar invitation to go out, but that's what our June presentation will be over. I appreciate everyone attending today and taking time out of your day, and thank you very much. Have a great day.
All right, thank you, everyone. Thank you.